If we can move on to the fourth question, just because for the lawyers here, is there a standard of evidence in impeachment trials, or should there be? And the reason why I ask is that in 2012, when during the Corona impeachment, one of the key issues raised by then Senator Santiago, Defensor Santiago, was what would be the standard of evidence. Now, for non-lawyers, the standard of evidence is basically how much proof should there be before a particular judgment is given by a court, and in this case, the Senate. Is that question at all relevant? Does it risk the over-legalization of impeachment, and what would be the consequences of that? Commissioner Sarmiento, and then probably Professor Te and Senate President Drilon.
If I recall right, it was an issue during the impeachment of President Estrada. And again, an issue during the impeachment of Chief Justice Corona. What is the quantum of evidence? Should it be proof beyond reasonable doubt or sufficient evidence? Again, to the best of my recollection, it was not proof beyond reasonable doubt, which is very difficult. I think it was sufficient evidence would be enough as guide for the senators in, well, convicting or acquitting the respondent.
Well, I don't think proof beyond reasonable doubt is a standard. That's only for crimes, I think during the time of, during the impeachment of Corona, what was actually followed was overwhelming preponderance of evidence. Preponderance of evidence, in one case it has been said that it's more than 50% chance of getting the desired result. So, again, it's because it's the Senate which is given the sole power to come up with its rules, then we respect whatever burden of proof the Senate will exact from the parties, but certainly not proof beyond reasonable doubt. Thank you.
Senate President Drilon.
Remember that the senator judges are not lawyers. Maybe some are lawyers, some are not. But having said that, there is simply no standard of evidence that is required. Each senator judge would make a judgment on the basis of his or her appreciation. There is no standard that is imposed because it's simply not possible to impose that kind of standard. Because in the first place, we say that the impeachment court is a class of its own. So, from that alone, you can have many consequences. And it's difficult, really difficult to impose any standard because the members of the court are simply politicians in the first place. They are not lawyers in every instance. So it is addressed to their conscience how they would perceive the evidence presented.
Thank you, Senate President Drilon. For Prof. Gwen and Prof. Ted, I wonder if you can tie this question to questioning the question, the larger issue about the way that law and politics interacts in impeachment. Because it does look like and feel like a legal proceeding. We call the senators senator judges, there's a prosecution team, there's a defense team, but in the final analysis, it seems like a lot of the rules that we would apply to courts actually do not apply to the Senate. And what would that mean for questions like evidence or burden of proof?
Thanks for that question. The first thing that I'd like to say is that the very first rule under the rules of court regarding evidence is that it applies only for judicial proceedings. So when we talk about evidence, unless the Senate expressly adopts the rules on evidence, which I do not think it should, because as Senate President Drilon pointed out, they are not all lawyers. So, the complicated, technical nuanced appreciation of evidence may not work for all of the senators who are not lawyers. They are not trained in those rules, and therefore it shouldn't bind them technically. Secondly, because of the political nature of impeachment, I think the standard, and I wouldn't say standard of evidence, the standard I think from which any evidence is appreciated by the senators should be, what would I, as a senator, need to be convinced of to remove this elected official from office and bar this official from ever being able to assume office. Whatever that standard is, that should be how the senator views the evidence. Because again, you can't use preponderance, you can't use a reasonable doubt, you can't use substantial evidence, which is so low a bar in terms of administrative proceedings. And because it's sui generis, as SP Drilon points out, I think the point of view of the senator should be, hearing everything that I've heard, does it convince me, does it answer this question for me, that this impeached official should then be removed from office and should be barred from ever assuming office? And that's a very heavy burden. That's a very difficult question because, again, you're contending with, an elected official who has been put into office by the will of the people, and your vote as a senator is essentially to override that decision of the people, right? In putting that person in office for whatever offenses this person has done, and that has been proven. So I do not think the standard should be the legal standard that we lawyers are used to. I'm trying to recall who it was who said, I think it was Senator Lapid in the Corona impeachment. His explanation of vote was so simple, from the point of view of an ordinary person. You may agree or disagree with his explanation of vote, but that was how he perceived the issue. And so I think from the point of view of the senators, when they're viewing the evidence, they should be viewing it with the end in mind of answering that question. What would convince me that this person should be removed from office, overriding the vote of that this person got, and perpetually barring this person from ever holding any office? Those are two very difficult questions to answer. And maybe just as a third point, Paolo, in relation to the use of evidence, over judicializing the proceedings, right, may also get in the way of impeachment as a mode of truth telling, of finding out the truth regarding certain transactions, certain grounds. Because again, the litigators know that one way to get a judgment in your favor is to make sure that the evidence never gets in. So hearsay objections, all of those things, right? But if for example the Senate takes on a very an overly judicial approach towards receiving evidence, right? And therefore there's hearsay objections all around. Essentially, you don't get to hear what's behind the accusations, right? And so maybe a shift in the mode, right, of adversarial, which we're used to in court, right? People versus X and Y, A versus B, from adversarial to inquisitorial, where the Senate, acting as inquisitors, right, basically try to find out, is this true? And even if it would be hearsay, right, as long as it is supported by enough corroboration, perhaps the Senate can go beyond that. I say that because of the qualification that the rules of evidence are really for judicial proceedings. They're not really for other types of proceedings.
But the rules of evidence is suppletory to the
Yes.
rules of the impeachment court.
Yeah.
And if let's say an objection is raised on that the evidence is hearsay, that can be ruled by non-lawyers. That can be decided by non-lawyers because that is put to a vote in the impeachment court. So, in that sense, the rules of evidence has a supplementary application.
I agree, sir. But what I'm simply, I think, pointing out is that we should not overly judicialize the proceedings. Because I think the other function of impeachment, the trial itself, which sometimes gets overlooked because of the adversarial nature, the perspective that it is adversarial, is the fact-finding, the truth-telling aspect of the impeachment court.
Scholars would actually call it not so much legal accountability, but political accountability.
Yes, political accountability.
And hence the morally coded words of the Constitution on impeachment. Prof. Gwen, before we probably go to the last question.
Maybe just 2 quick points. To the question, I agree with Senate President Drilon. The Constitution does not itself require any standard of proof, nor any quantum of proof in the impeachment trial. And from a practical perspective, I think it will be difficult to impose such a standard because the determination of whether the impeached official's conduct rises to the level of an impeachable offense is addressed to each senator judge. Because at the end of the day, the conviction or the acquittal in an impeachment trial is just a matter of votes. So we look at, so that question is really addressed to each senator judge, and as Senate President Dillon mentioned, not all of them are lawyers. The second point is, while we're discussing burden of proof, I think there are 2 important sort of strands to that question that the Senate should pay attention to. One is their crafting of their rules for the impeachment trial. In the past, I understand that they have adopted the rules of evidence in a suppletory manner. We don't know whether that has affected in any way the capability of a non-lawyer senator judge in receiving information. That's one. The second is if it has affected the capability of parties, for example, the House managers or the House prosecution panel and the defense in terms of presenting information to the Senate for purposes of each judge making that decision. Lastly, also the role of the presiding judge. So in the last 2 impeachment trials, both were lawyers. So Chief Justice Davide and Senate President Juan Ponce Enrile. And you will see in how they've managed, I don't want to say judicialization, but you'll see on one hand how previous experience in running adverse proceedings has helped expedite the proceedings, how quickly they decide on motions. But at the same time, we don't know whether that has in any way disadvantaged those who are senator judges without similar experience. So apart from quantum of proof, and again, I think there really isn't one that we can impose. We should look at the role of the presiding judge and also the manner by which the rules for the trial will be crafted by the Senate.
I think ultimately as well, if we go by the language of Corona and Estrada impeachments, there was a lot of language pertaining to conscience, whether the conscience of the senator judges would be satisfied by the vote that they would or would have ended up taking. We have just a few minutes for the very last question for this panel, which is very timely in light of events in just the last week when we planned this impeachment forum. There was no case filed yet to the Supreme Court, and now we have 2. Right? So if a case is brought to raise these questions, may the Supreme Court step in. And I think, for our audience who may not be lawyers or law students, there's a question there's a difference rather between whether the court can step in and whether the court should step in? May kapangyarihan ba siya o dapat ba siya manghimasok doon sa issue na iyon? So, your thoughts on this, Commissioner Sarmiento?
Address the last question. As of today, the Senate has not been constituted as an impeachment court. So not yet the sole power to try and decide this case. So if addressed, that question, may the Supreme Court step in. Now there is this provision, forthwith proceed. That's why a petition has been filed by a lawyer for the Senate to observe, to follow this command, forthwith proceed. So up to this point, it is not yet an impeachment court. It's not a political question. I think the constitutional duty has to be addressed by the Supreme Court. Now, on the issue of the second petition that was filed with the Supreme Court yesterday, questioning the whole process that was followed in the House of Representatives. Again, there is a provision in the Constitution that's to be followed. I think the Supreme Court can step in and come in and resolve this petition.
Thank you, Commissioner Sarmiento. Senate President Drilon.
The basic rule is found in the Constitution. The impeachment court shall decide all impeachment cases. Questions of jurisdiction, therefore, should be decided by, according to the Constitution, by the impeachment court. To me, the better attitude that the Supreme Court can follow is not to interfere. Let this be treated as a political question and therefore leave it to the judgment of the Senate asking or acting as an impeachment court to decide on this, including questions of jurisdiction. So it's best that the Supreme Court does not interfere.
Justice Carter Morales, I know that there might be a discomfort in light of the Francisco ruling. But
Under the expanded jurisdiction of the Supreme Court, the Supreme Court can take jurisdiction in actual cases, actual controversy that involves the rights, demandable rights of people. And when there is abuse of, or grave abuse of discretion. So, for as long as the question is not political, but there is abuse of discretion, grave abuse of discretion on the part of the respondent, and or there is an actual controversy that involves demandable rights, the Supreme Court can step in. Thank you.
In other words, the decision of the impeachment court can be appealed to the Supreme Court?
Why? Are you sure there was abuse of discretion?
Well, just my point, Chit, is that under the Constitution, the Senate shall have the sole power to try and decide all cases of impeachment.
Precisely.
This is precisely a clear rule that the Supreme Court should leave the Senate alone.
Precisely, I subsume my answer in that there is, under the expanded jurisdiction of the Supreme Court, as afforded by the 1987 Constitution, the court comes in if there is an actual case and it involves demandable rights and or there's grave abuse of discretion. If the impeachment court gravely abused its discretion, why should it not step in?
Because the remedy is not to re-elect the senators that rendered such an unjust judgment.
You tell that to those who are electing and re-electing.
if I can just provide context to the discussion, before the 87 Constitution, I think there was, impeachment was clearly beyond the interference of the intervention of the judiciary, that might be a better word. But the position since 87, at least by the court, is that there are some questions that were formerly, the court would not really decide, are now fair game for the court's decision. I think Senate President Drilon is on the side of the traditional idea that, the impeachment is a political process, the court should step back. Justice Carter Morales is more on the expanded jurisdiction of the court. If Prof. Gwen and Prof. Ted can weigh in, just as...
Go ahead. On the matter of electing and re-electing.
Yes. I want that that point should be given emphasis. But to your question, I agree with Justice Carpe Morales. As the Supreme Court has done before, there are questions related to impeachment which the court has considered to be justiciable, so long as the standards for adjudication are present in the Constitution. But having said that, I understand your question to mean any of the questions we've discussed today could be subject to sort of judicial review. On that point, I agree with Senate President Franklin Drilon. I think this is an opportunity for the Senate because the articles of impeachment have already been transmitted, or the impeachment complaint as the articles of impeachment has already been transmitted to the Senate. I think we should give the Senate the opportunity to take on the role that it has been constitutionally granted, so that its action will inform how these provisions are enlivened, rather than by default letting courts decide questions that have been addressed by the Constitution to the Senate.
Thank you, Prof. Ted.
Yeah, there's a balance that is struck by the Constitution among the three branches, and that balance is now being implicated whenever impeachment comes in, because there are two branches of government currently now being involved with the impeachment of the Vice President, and then the action of the House, and then the possible action of the Senate. You are now bringing in the third branch to mediate in a way between these two branches of government. And so, knowing the court to also be a practical court, meaning will its action actually do anything in order to help the situation or not exacerbate the situation. While I agree that yes, the court has jurisdiction to entertain petitions that fall within Article 8, Section 1, Paragraph 2 parameters, the question of should it is a more difficult one simply because of that balance. And on a practical matter, for example, in one of the petitions, where the petition asks that the Senate forthwith proceed, meaning should try, right? When the court, I imagine if the court acts on that, and if the court acts favorably on that, that would mean the court would be setting the timetable basically for Congress to do certain things, where objectively those conditions may not exist. And so I think that would be within the mind of the court. Can we actually grant this relief, considering the objective conditions do not exist? The Senate has not been constituted yet as a court. If we do grant this, how will the Senate proceed? Because the court cannot order the Senate to constitute itself as an impeachment court. They cannot order that in whatever petition. So that's why I preface my answer with that there's that balance, and the court now being called to mediate, to thread that balance. The court will have to look at the practical side of its decisions. Yes, the jurisdiction is there, but I think the question would be, should it exercise its jurisdiction at this point, and maybe not when at a future time when maybe the issues have been a bit more crystallized, as opposed to at this current time. I hope I don't get cited for sub judice for that, but that's my opinion.
I think what lawyers would call ripeness, when all of the facts are already there for a court to make an informed decision. That has been an incredible hour and a half, and I hope, I wish we could continue the conversation, but may I ask our audience to give our speakers another round of applause. I hope our speakers can stay up to the open forum towards the last few minutes of today's session, but in the meantime, may I call on Professor John Molo to introduce the speakers for the second panel.